we essentially work on a contingency fee basis, which means we work for free until we win your case.
How do lawyers in Alberta typically structure their fees and billing arrangements? We're going to talk to lawyer Steve Grover about that on today's episode of Ask the Lawyer. Steve, thanks for joining us.
Hi, Molly. Thanks for having me again. Hope you're doing well.
Same to you. First off, what are the different types of fee structures commonly used by lawyers in Alberta?
Well, I mean, I've been practicing personal injury for over 23 years here in the province of Alberta. We essentially work on a contingency fee basis, which means we work for free until we win your case. So essentially, what happens is, you know, if someone's happy with hiring our law firm for their personal injury accident, be it a motorcycle crash or a trucking accident or even a slip and fall, we would have them agree to a contingency fee agreement, which means we take a settlement, partial of the settlement at the end. It's usually a flat 30%. That fee does not increase as the case goes on, even to trial. I think that's a fair fee structure of 30%. And essentially, that's how we work is essentially, until you win your case, you owe us nothing. And, obviously the more money our clients make, the more money our firm makes. So there's incentive for us to work hard and put the same person in the same position he or she was before the crash.
Now, is that for all firms in Alberta, all types of cases? Do lawyers ever charge hourly rates or a flat fee for any of their cases?
Yeah, I mean, it's usually for any kind of personal injury case, like a car accident, a motorcycle accident, even a medical malpractice claim. We're allowed to charge a contingency fee, which means we work free until the end. We take a percentage of settlement. Obviously, if you're involved in a criminal matter, if you're arrested for robbery, obviously a criminal lawyer in, province of Alberta would charge you a flat fee, usually an hourly rate. Obviously, there's corporate lawyers. If you need someone to do an incorporation for your company that you have, they would charge you a flat fee for that. And then obviously, if there's any corporate matters going on forward, they obviously charge you per hour. But our industry is a little different. I mean, obviously, in personal injury, most clients could not afford our services. So we work on a contingency fee basis, which means we work for free until the end.
So, is it customary for lawyers in Alberta to charge interest on disbursements incurred during a legal case?
Well, I mean, that's an interesting case because recently it's come up here in the province of Alberta where, lawyers like myself are working for free. And, we'll charge 30%. Some lawyers charge 35. I've heard another lawyer in town charging 40%, which I think is way too high. And then some lawyers I've heard charge interest on their disbursements because you need the disbursements to prove your case. We need the medical records. We need a medical legal report. We obviously have to send our clients sometimes for an independent medical assessment. That all costs money. We have to pay court filing fees. And I found it interesting. I found out in Alberta, some lawyers charge interest on the disbursements. And, here at Grover Law Firm, I don't do that because I believe that the client is entitled to more money than the lawyer. And I've heard accounts where, the client pays 33% at the end. And on top of that, they're paying $10,000, $12,000, $15,000 in interest on the disbursements. And I mean, for myself running my business, I don't think it's fair. Some lawyers choose to do that, and that's their choice. But, here at Grover Law Firm, we just charge 30%. Our disbursements are finance free because that's the cost of doing business if you're in this industry. Because I want the clients to be represented properly. I want to get the best case possible, get the best expert for the case. But they want to resolve the case. I want the clients to walk away with more money than the law firm does because they're the ones that are injured. And they need the money to rebuild their life and get on with their life also after an unfortunate accident.
So it sounds like those fees can really vary depending on whom you go see. Are there any regulations or guidelines governing attorney fees, disbursements, and interest charges in Alberta?
Well, here in Alberta, lawyers are governed by the Law Society of Alberta. That's a regulatory body here in Alberta. And, there's certain things that the Law Society has set out that has to be in their contingency fee agreements. And you can always get that agreement reviewed by the taxing officer at the Court of King's Bench here in Calgary, Edmonton. So there are, standards of what has to be in the agreement. But at the end of the day, regarding, charging whatever contingency fee, I think that's just what the market offers. If you can get away with charging 40%, I mean, I guess some lawyers do that. Regarding interest, I mean, obviously, to run a large personal injury practice, you need lines of credits from the bank, and they charge you interest. And some lawyers charge their interest that they, when they delve into the line of credit, or they just think they should be charging interest on disbursements. And at the end of the day, we don't do that, but that's really up to the law firm in particular. So when you go with a law firm here in Alberta in a personal injury accident, be careful. Look through the contingency fee agreement. If you're okay with having the lawyer charge you interest on disbursements, go ahead. But that's not our practice here at Grover Law Firm.
So, how can clients ensure transparency and clarity regarding lawyer fees, disbursements, and interest charges in Alberta?
Well, I mean, at the end of the day, lawyers here in Alberta, like any kind of jurisdiction, even if it's down the state of Alabama, you're governed by the state bar or the Law Society of Alberta here in the province of Alberta. There's a code of conduct. You have to be honest. You have to be ethical. You have to be upfront with your clients. If you can't be upfront with your clients, how can you represent them properly? And I think it's really important for clients to understand that the lawyer is here for your best interest, to represent your legal interests. Obviously, we got in the business to helping people here at Grover Law Firm. Money second. Money will come and go, but I think the most important thing is the health of our clients, to make sure that they get back to their normal life in the way they can as before the accident, subsequent to this crash. So I think it's really up to the lawyer to be honest and upfront. At the end of the day, when a claim is settled and the money comes into the law firm's trust account, we have to do up a statement of account. We have to review that with the client, in particularly go through every item, make sure he or she is good with it, and then have them sign the release so they understand, what their fee is. If there's any money owing for any kind of treatment assignments, we let them know about that. So, there's an obligation of a law firm in a personal injury practice to give them a statement of account like any other kind of law firm. If you're doing a corporate account, or a merger acquisition, you have to render an account to your clients to make sure they understand where all the money went.
Steve, great information today. Always nice to talk to you.
Yeah, always nice to see you. Hopefully you have a great summer, and hopefully everything's good with you. Thank you.
You as well. And that's going to do it for this episode of Ask the Lawyers. My guest has been lawyer Steve Grover. If you'd like to ask him about your situation, call the number on the screen. Thanks for watching. I'm Molly Hendrickson for Ask the Lawyers.